had multiple stab wounds. Some had defensive wounds, showing they fought with the attacker. And there was no sexual assault. County Coroner Kathy Mabbutt is describing the murders as personal.
Okay, guys, I'm here and I think I'm ready. I'm really anxious today. I still get anxious sometimes doing live streams. I'm like feeling that way right now. I'm just letting you know I'm in a little bit of a funky mood for a number of reasons, nothing having to do with you little wonderful. So I'm so happy to see you guys. So if I'm not my normal chipper self, that's why. And maybe some people will like that better because a lot of people tell me well, she obviously likes to hear herself talk more than anything else. So I think I just do that because I'm usually nervous, or sometimes, depending on the content, I do have a lot to say, especially with the Watts case. So yeah, hey Chris. Yeah, so I was gonna email you really quick, but my evening just got really busy. I obviously switched topics. I first was gonna do a members live stream tonight on a few different things. I really wanted to talk about the Apple River stabbings because they closed testimony, which I thought was really quick. I thought it was going to last a little bit longer, and I really want to see what you guys think of that. But there's more time. And then I was going to do a live stream talking about the former Watts residence, 2825 Saratoga Trail, being up in the market again. And I actually prepared a lot for that. And I'm going to do a Watts thing tomorrow night. It's not going to be on that topic. That's just going to be some extra. Oh boy, are you guys in for some crap tomorrow night and upcoming with the Watts content? Oh my God. But we can't do that all the time. Even though this is Watts the Obsession, it wasn't the intention to make a true crime channel that was, going over 3 years that only talks about the Watts case. So, and then, I knew that this was going on today. And then when I started to look at the coverage after the hearings, I was like, oh my God. And I thought it was going to be good because I need to know how many of you are aware of what is going on with the Bryan Kohberger pretrial, goings on and the defense juror survey to ultimately determine if, they kind of changed their tune in what they said today, but this is really what it's about. I mean, I don't okay. I'm gonna save my opinions for later. Let me just tell you what's going on. To determine if they could find an unbiased jury pool in Latah County, or if this trial requires a change of venue to ensure that Mr. Kohberger gets a fair trial that he deserves and he is guaranteed under the United States Constitution. I personally do believe, with the evidence I have seen, as many of you know, it's looking to me like they do have the right man and he's probably going down. But I don't know that. And it's really important that he does get a fair trial, right? So how many of you are aware of that whole potential juror survey issue? If you're aware of it, please put a 1 in chat. And if you're like, what are you talking about? Please put a 0, just so I can kind of know how much context I might need to give you. Oh, Cherry, you're so good to me. Thank you so much for the $10 super chat. I really appreciate you. And thanks for being here. How are you doing, my dear? It's always nice to see you. My chat regulars. Let's see, who is there? McJay, Veronica, Clover, Sean, how are you doing? Bubba's on. Hey, Bubba's on. It's nice to see you often, sis. And Honey Bun, hey. Angel D, I'm not going to say hey to everybody. I'm just going to go through your names so we all know who's here. Anaphylaxis, thanks for being here, sweetheart. Jody is cool. Ara, myself, Chris, the person who was on the last live stream we did, who also has a behavioral therapy degree and was amazing. I know a lot of you guys loved her. I'm going to try to get her back again because she was so awesome. Thanks, Chris. And gosh, if I did miss you, I'm so super sorry. It's not intentional, but I just want you guys to know who's here. Okay. Hey. Okay. All right. Let me just play a little bit of the background kind of information, okay? And then we're going to go into what happened today. And I didn't prepare like a ton of content for this live stream like I often do. I'm just kind of watching this with you guys because I'm just doing my best today, because sometimes we have days where we can just like try and do our best, and that's what's up. So that's my day. All right. Let's see. Oops. Hold on. I just got to pull that into the stream here. Yes, that's it. Okay. So, and how are you guys doing? How's everyone doing today? I don't even think I asked you that. I'm sorry. I just kind of launched off talking about my funky things. Oh, thanks, Chris. Oh my God. Oh my God, Sherry, that's terrible. She said her stepson has 3 to 6 months to live. I'm so sorry to hear that, Sherry. Oh my gosh, that's terrible. Please let us know if there's anything we can do to help you or support you. Okay. I'm so sorry that you're going through that. Life is precious, my friends. Wow. I've definitely learned that lesson more this year than any other time period in my life. That is for sure. Just found out my stepson has colon cancer. Oh, I'm so sorry. Oh my God, I'm so sorry, Sherry. I am just so sorry. Please, I'm going to email you after this, and please let me know if there's anything we can do for you or him to support you guys, okay? And please don't be afraid to ask, because we have to be here for each other, okay? Jeremy, hi Jeremy, how are you doing? And hi Crystal, how are you doing? Jeremy says, for a guy who says he is innocent, he sure has no problem spending years and years in jail. Well, that is one of the things that in my mind really does point to the fact that I personally believe that the prosecution knows that they have a slam dunk case. I could be wrong. Maybe the trial's going to pan out and I'm going to be like, oh guys, woo, I was wrong. Check that out. And that's fine. But this is just, this is how I'm feeling about it by watching carefully at this point and talking to people who know more than me about the judicial process. So, first of all, and we can understand that this is true if we look back at death penalty cases. Before prosecution is going to put death penalty on the table, they're going to be damn skippy sure that they are going to get a conviction, because, well, first of all, once you put death penalty on the table, it's a much higher bar for the jury. The jury has to, of course, be death penalty qualified. And studies have shown, tried and true behavioral, like scientific method studies have shown that even a death penalty qualified jury is going to have a much harder time, they're going to need more evidence to convict somebody, basically, without going into all the details of what those studies show. And we could go over that sometime if you want to. But also, these attorneys, what we are seeing playing out right now, the preparation that they're doing for this trial, and when the trial actually goes down, this is their career. This is their life's work. I dropped out of law school a year and a half in. It wasn't quite a dropout, but I left it, and it was hard. And that is certainly one of the reasons. There are other reasons too, but I don't know if I could have made it through. I don't know if I could have passed the bar. I don't know if I could have been a practice. I don't know. They put a shitload of work and money into doing what they're doing right now. And the lifestyles that they live probably is pretty dependent on that nice salary that they get that they might not be able to get if they were not practicing attorneys. So just even for that reason, and hopefully also for the sake of justice, to put the death penalty on the table when they know they don't have a super solid case is poor practice. It's irresponsible, and prosecutors do not do it. That's what I've observed, and that's what I've been told. So, yeah. Oh, thank you so much. Oh, thank you, Chris. I appreciate that. Thank you for the super chat. She said, thanks for being so kind and sharing your platform with us all. Well, thank you guys for being here. I really appreciate our community. Thank you. I appreciate that. You are a doll. Thank you. Oh my God, I just pulled a muscle just doing nothing. See, this is how the day's going. Okay, without further ado, before I break something like in my body, I'm just going to start playing this, okay? Okay.
What the agents of the defense have done is they have outgone and interrogated.
Oh, let me know how the audio is.
And it's outrageous.
Fighting words in the Bryan Kohberger case as the defense reaches out to potential jurors as they try to get a change in venue.
There are two things that have happened without me being able to even weigh in that's done when the prosecutor asks you to do something. And I don't like that. I want to have opportunities to be heard.
Judge is not happy after the defense claims that he violated Bryan Kohberger's civil rights.
I told you that I was going to set a hearing. So I don't know what your understanding is with just the process.
There were some recent fireworks in the Bryan Kohberger case, and it all stems from his lawyers wanting to move the trial out of Latah County. Bryan Kohberger's lawyers hired someone to do a survey of potential jurors in Latah County after University of Idaho students Madison Mogen, Kelly Gonzalez, Ethan Chapin, and Xana Kernodle were murdered in an off-campus house in November of 2022. The reason for the survey? To see how tainted residents of Latah County might be against defendant Bryan Kohberger. Prosecutors say that the defense conducting a survey is not a big deal, but what has them upset are the questions the trial consultants asked the 400 residents when they called them up on the phone.
Have you read, seen, or heard if Bryan Kohberger owned the same type of car reported on video driving in the neighborhood where the killings occurred? Have you read, seen, or heard if the cell phone tower data showed that Bryan Kohberger made several trips near the victim's home in the month before the killing? Have you read, seen, or heard if the university students in Moscow and their parents lived in fear until Bryan Kohberger was arrested for the murders? Have you read, seen, or heard if Bryan Kohberger said that he was out driving alone on the night of the murders? Have you read, seen, or heard if Bryan Kohberger stalked one of the victims? Have you read, seen, or heard if Bryan Kohberger had followed one of the victims on social media? Your Honor, there is absolutely no question but that those questions are disseminating by means of communication evidence expected to be presented, evidence that could be or would be inadmissible at trial. And I will say there are a number of these representations placed in the form of a question, but representations of fact that are not true or that would not be offered at trial.
Now, much of this information has already been put out there to the public, but prosecutor Bill Thompson argues that that doesn't matter. It still violates the non-dissemination order, an order that Ann Taylor requested. Here's what Ann Taylor has to say about everything. Now, before I let our girl Annie speak, I just want to tell you that, today I was thinking about that a lot. Like what angle are they going for here? And today, something that came out during the course of Bill Thompson and Ann Taylor and Judge talking, and woohoo, things are getting a little heated in that courtroom. Okay, I'm going to wait. I want to hear what you guys have to say before I give you my full opinion on that. But they said, well, yeah, so some of the questions that we are asking, the context of it, in the potential jurors telephone survey are things that are factual and actual, and some of them are bullshit. They're not real. Like, what? So wait, so you're trying to confuse your potential juror pool before you actually convene a jury? Like, WTAF is that? Now, I did get a chance to speak with my friend Alex, who is the only member left of the Watsy Obsession legal consultant team, briefly, because we had talked about something else earlier today, and I asked him about this whole thing. His wife and I were talking about it, so I asked him about it anywho. And he thinks that this is freaking insane. He said that this is what he said to me, potential juror surveys they don't look like, the questions are not composed in the manner that they were on this survey. And let me get through the rest of this. And I guess I'm going to let Ann speak. Okay, we'll let her speak. And then I can come back to that if you guys want me to.
This court and counsel knows how much coverage this case has received. And he does what he does by looking only at what's in the public. We didn't provide him any police reports. We didn't.
I'm sorry. It's just that does miss the point. I mean, it's kind of ironic that we have worked so hard, including you, okay, both sides, to protect a fair trial. Okay, and our concern from the very beginning was all the media stuff floating around.
Whoops. And judge, and friends, you better continue to work just as hard to ensure that, because we are watching. And don't worry, Rourke, I'm coming back for you, baby. I'm gonna get you. Don't worry.
Okay, that affects your client, Mr. Kohberger, to get a fair trial. And some of these questions actually create a concern about that they're inculpatory. It could be prejudice for his client. Okay, and that I'm just surprised that both of you didn't come together and say, there are certain things that we probably shouldn't put into the public on a telephone call. It really concerns me, and that's why I did what I did that.
Now, Ann Taylor says that she did not approve the questions, but she did approve the topics, and the survey is anonymous. Well, things got pretty heated when the judge violated Bryan Kohberger's due process rights by halting the survey. Oh my God. And I just want to say, and you guys probably know this, or maybe you don't. Do you know what a big deal that is to accuse a judge of violating a defendant's due process? I mean, the whole reason, well, not the whole reason. One of their primary concerns and responsibilities, and one of the things they uphold as being most sacred in this justice system, is that the due process and the other backbone procedures that we have in place in democracy are maintained. So, I feel like this was really a below the belt accusation that was completely not warranted. It really makes me wonder what they're up to. And Clover, I'm starting to not like Ann Taylor now either. I didn't have a problem with her for a while. I'm kind of like, yeah, girl, yo, I see you. I see what you're doing. I think I do. Watch me be totally wrong. And I'm like, well, I'm just a person that only did a year and a half of law school. I don't know what she's doing. Duh. But I feel like we can kind of see her game. She's trying to get, I'm going to talk about in this video here, so I'm not going to repeat it twice, but this is really rubbing me the wrong way. I do not like it. I think it just comes off as not good to me. Let me know what you guys think.
Which is a whole big issue for me.
I can understand that would not be taken. I have to represent my client to the best of my ability. And the reason for that, Your Honor, with all due respect, I was shocked to see the court issue an order within hours of the state filing a motion late on a Friday without giving us a chance to be heard.
Oh my God.
My order didn't say it was permanent,
Maybe
and
I,
it told you that I was going to have a hearing.
maybe I phrased that very poorly. It's a decision that you already made.
Okay, let's go back. I got the motion at 4:30 on Friday. Now, it doesn't even reflect, just when it was filed, because Odyssey has a delay, right? So I get the motion at 4:30 Friday. I get a response from you at 4:45 Friday, right?
I don't know what time you received it, but I filed an
That's what I
objection the
got.
minute I could.
Because then you know that about 5 o'clock, that's when I issued that. So I had a half an hour. I read the materials that were attached to the motion that the state filed, and I had very little information. But it seemed like there were some real legitimate concerns about the survey. And obviously, it turns out there are concerns, legitimate concerns about what was done in the survey.
Oh, the boys. Well, Ann Taylor did say in her motion to rescind the hull of the survey that she felt that Judge and Bill Thompson were basically having discussions and making decisions behind her back, which, as you know, are something that you just do not do in the United States judicial system. So here are how things ended with that survey.
Hey, Judge, I'm confused. What are we going to have a hearing on?
Well, I want to see what thoughts you all have about dealing with the situation now, making sure that we can salvage anything or nothing. And Ms. Taylor's going to talk to Mr. Ellman, and maybe that'll give us some thoughts. Otherwise, I could just make the decision right now, but I'm no expert about surveys.
What do you think about this issue? Is this another means the defense is trying to employ to be sneaky and getting information out to the public that may not otherwise be admissible in court, that they might not find out through court proceedings? In other words, is this the defense's attempt to taint the jury pool, or is a prosecution overreacting? So let's take a look at some other times historically that Bryan Kohberger's defense has done this during the pre-trial phase.
Tonight, a bumpy start to a lengthy court battle from the defense team of alleged Idaho murder suspect Bryan Kohberger. His team attempting to force the surviving housemate of the Forest Lane University of Idaho students to testify in his defense at a preliminary hearing in June. That roommate, Bethany Funk, is fighting against it, filing her own motion to quash the subpoena in Washoe County, Nevada.
And newly unveiled court filings are shedding light on how the defense team for Bryan Kohberger is trying to play things out. In the filings, his defense asserts that a surviving housemate has exculpatory evidence, information that could be favorable to Kohberger.
According to the court documents, Kohberger's defense team says she has, quote, information unique to her experiences and cannot be provided by another witness. Funk.
What a dumb statement. I've always thought that was such a dumb statement. Everyone is going to have experiences unique to, or whatever, unique to their own experiences of, reality that can't not be experienced by other people. It's such a dumb statement. I can't believe that actually made it into a legal document, because it is not the definition of a material witness. But moving on.
Is fighting the subpoena. Her attorney filed a motion saying even if her client has exculpatory evidence, which remains unknown, quote, there is no place or reason to present that evidence at a preliminary hearing.
As we all know, that preliminary hearing never happened because the state convened a secret grand jury, and, well, history in this case had been made. However, I think along the main goal of this motion to compel Bethany Funk's testimony in the pretrial hearing was for Ann Taylor and her team to get information out to the public and to the potential jury pool that there might be exculpatory evidence out there. I mean, how else would you be able to do that with such a strict and broad gag order in place? It truly is. How'd you do that? You won't be able to. See? So I'm just saying this is an example of the same game that, in my opinion, the defense keeps playing over and over again at every opportunity. And when there's not an opportunity, it's starting to seem like they are creating opportunities. And that is not good, because that's when we buy a ticket to the circus rather than watching justice take place. You know what I mean? It's amazing to think about the amount of information that the defense team, Bryan Kohberger's defense team, led by Ann Taylor, has managed to get out to the public, to the masses, to potential jurors in the midst of a strict and broad gag order that has been in effect since January 5th, 2023. So let's think about one of the first times that we heard from the defense in a big way, and a way that made headlines. And that was the defense's motion to compel Bethany Funk to testify at the This is just like 2 more minutes, and then we'll get to today's events. I just kind of want you guys who aren't familiar with, the patterns of the defense's like mojo right now to kind of, feel the vibe, so you can catch the rhythm of what they are doing, in my opinion, allegedly. Trial hearing. So what was the defense's reason for compelling her to testify in that pretrial hearing? Well, according to what they had to say, it was because Bethany Funk had exculpatory evidence that could, well, by the definition of exculpatory evidence, they're saying that could exonerate Bryan Kohberger. Exculpatory evidence is evidence that shows that somebody is not guilty of the crime for which they are charged. The person who is authoring this document introduces himself as an investigator that was retained by the defense for Bryan Kohberger. And I'm starting here at line 7. It says, Bethany Funk's bedroom was on the 1st floor. The other surviving roommate's bedroom was on the 2nd floor. Bethany Funk was interviewed by police on several occasions. She disclosed things she heard and things she saw. Bethany Funk was present at the home 8 hours later when police were called, arrived on scene, and discovered the homicides. The statement in the document goes on to say, during the course of my investigation, it became known to me that Bethany Funk has information material to charges against Mr. Kohberger. Portions of information Ms. Funk has is exculpatory to the defendant. Ms. Funk's information is unique to her experience and cannot be provided by another witness. So what exactly could this exculpatory evidence be that the defense is continuing to allude to? Now, understand that the defense is under ethical guidelines that, according to the oath that they've taken to be an officer of the law, to be a member of the American Bar Association, they can't just throw out statements that are baseless, that don't have any foundation in fact or any kind of evidence that they are aware of. So for the defense to say that they believe that a certain witness has exculpatory evidence, it's under the scrutiny of the court eventually, if they choose for it to be under their scrutiny, to test the validity of the statement, at least the knowledge that the defense attorney had in making that statement at that time. So Ann Taylor is well aware that she is representing a defendant in a very high profile case. So unless she's going to put everything on the line, unless she's going to put this trial on the line and her career as an attorney on the line, we have to believe that Ann Taylor has a good faith reason to assert that she believes Bethany Funk might have, or she says has evidence that may be exculpatory to. So I'm going to end that there. So now the point of that really is, guys, okay. So those of you who have been with me for a while know that I disclosed one time, and I will not be talking about it again for legal reasons. And that's all I have to say. And this is the only time I'm probably going to mention it for a while. So just let that sink in. And I wasn't alerted by nasty YouTubers or anything to not talk about it anymore. It was for legal reasons. All right. So, but I did disclose with the two frat guys that I've been talking to forever. They have become friends. That's just how it is. They have been completely honest. I've talked to one of their sets of parents, and they're just decent people. Anywho, they felt very strongly that they knew what Bethany Funk's experience was. And I can't really tell you anything more about that because I explained before that we decided that to give that information was just going too far. But I believe you're going to find out. I'm sure you are. It was not by any means that I can understand or that they can understand or that their parents can understand or even that our attorneys we were talking with can understand. It's not exculpatory. So to, do that whole thing, they are, summoning her to give a testimony at the pretrial hearing because she's a material witness and might have exculpatory evidence. I truly think that was a load of crap. And I didn't come to fully realize that until, we talked in detail about what they are pretty damn sure they know her experience to be and then compared it to what the defense is putting out there. It's a little bit eerie, but yeah. So, all right. So let's get to today's hearing. So everybody all good? Do you have any questions? Are you all like, understand what's going on at this point? So I'm going to I have to just grab something from, I think I'm going to start out with a video from Law and Crime Network because it's only 13 minutes long. So I've watched the longer versions, on double time at some point today. If it doesn't give us everything we need, I have other ones we can go to, but let's see how juicy this one is. I have not watched this one yet. So let me just get it loaded up for you guys. And please let me know what you think in comments. And if anybody does want to come up on panel and talk, you absolutely are welcome to do that. Where the hell to go? Where to go? Where to go? I hate it when these videos just disappear on me. All right, just a moment. Oh God, I'm so glad I didn't talk about the Watts house being resold. So many people have videos up about that right now. All right. I mean, it's interesting, but Okay. So is this going to be the right one or is this from today? Yes. Okay, it is. All right. Let me bring it into the stream. And anyone who's just coming in, thank you so much for being here. Hi, Robin. Hi, Aussie Jen and Marie and Inka. So glad you're here. You're all good. And if anyone else came in, I'm just looking at the chat right now. So I'm so sorry if I missed you. It's not intentional. All right, here we go. Freaking insanity. Insanity. This is just so crazy to me. Oh, I can't wait to talk about it. Okay. I don't want to poison you with my thoughts before you make your own if you haven't seen this yet.
That was done. Yeah, and the hyperbole that keeps getting expressed in this courtroom.
Bryan Kohberger's defense team pushing back against claims their potential jurors violated a gag order and tainted the jury pool, while prosecutors cede no ground on the issue.
If it can't be done right, or if that's what it takes to do it right, then we need to do it. This is a big case. And the finger for this cannot be pointed at anybody but the defense.
Thanks for joining me for Crime Fix. I'm Anjanette Levy. Things are certainly heating up in Bryan Kohberger's case. Typically, things are pretty cordial between prosecutor Bill Thompson and Kohberger's defense attorney Ann Taylor. She actually worked for him many years ago. But things have changed a little bit and become more tense since the prosecution found out that the defense commissioned a survey of potential jurors in Latah County, Idaho. Kohberger has maintained his innocence in the murders of 4 University of Idaho students, Maddie Mogan, Kaylee Gonsalves, Ethan Chapin, and Xana Kernodle. Prosecutor Bill Thompson talked about the survey questions that were asked to the 400 residents in Latah County by phone. He claims those violated the court's non-dissemination order. They included things like, did you know Bryan Kohberger was arrested at his parents' house in Pennsylvania? Did you know DNA found on the knife sheath matched Bryan Kohberger?
And the state's position is that the fact-specific questions, and I understand, Dr. Edelman, why the questions are asked. I understand his explanation. It doesn't change the fact that we have a non-dissemination order that specifically prohibits that kind of dissemination of facts, specific facts about this case.
But there were questions that contained false information that really got the prosecutor mad, specifically when Bill Thompson cross-examined Dr. Bryan Edelman, who's conducting the survey. Take a look.
I hope this is a part that I think it is, because I think that our boy Bill Thompson Claus had such a good point here. Well, we're going to see.
You acknowledge false that Mr. Kohberger allegedly stalked one of the victims. That's false. You know that to be false.
Which one?
That Mr. Kohberger allegedly stalked one of the victims.
Yes, I was trying to.
So now the whole world knows that too. We all now know it is agreed upon by the prosecution and the defense. And it said right here in court. Now, and this isn't part I was thinking it was even, that Bryan Kohberger did not stalk any of the victims. That's out there by both sides. It's agreed upon. So I'm very surprised by that. What do you guys think? I'm very surprised by that. Like, what the fuck? If he wasn't stalking them, like, this is a little weird to me.
Not to say that.
I don't think it means he's innocent. It's just weird to me. And I think what it means is there is a perverted twist yet to come that nobody is even envisioning right now.
But you knew that was false.
I did.
So we learned something new there. A couple of media outlets had reported that Bryan Kohberger stalked one of the victims in the months before the murders. The prosecutor now says that's not true. But back to the issue at hand. The prosecution believes Dr. Edelman's methods tainted the jury pool and violated the gag order. Things got a little spicy.
I'm sorry if you're feeling hurt about us raising this issue. I see you were almost breaking down a few minutes ago when you were talking about slide number 33 on slide number 31. That's not the intent, and it's certainly I'm surprised to see that reaction from an experienced expert such as yourself. So I apologize for that.
I accept your apology, but the idea of after working really hard 15 years to develop a credible reputation and being told watching on a Zoom that I am tainting the jury pool and poisoning the jury pool and contaminating the jury pool by doing what's required and standard, I'm not crying. I'm angry. Okay. Yes, it doesn't.
No, okay. So this is where I just want to talk about what my friend said, who has told you guys a million times. He's a defense attorney. Let's see, he went to law school, but he went all the way through. I went into law school in 2001. So that's how long he's been a practicing attorney. He's a defense attorney. He's a pretty big time defense attorney. He's a non-for-profit. He's kicking ass. His wife is also an attorney. She's a different law, but anywho, he's the guy I was talking to today about this. And he says unequivocally what dude right here is saying on, what is the equivalent of national television will be broadcasted and syndicated on national television time and time and time again. He said it is unequivocally not true. And he could not believe that dude was allowed to be saying all of this mumbo jumbo, not true stuff, according to Alex, in court. Even though it's not the trial, this is going to be heard throughout the world. We get that, right? Like that, if that's powerful. This is getting Judge, I think needs to really rein things in a little bit, or Judge, my initial feeling about you might be right. So I hope you prove me wrong, but this is not looking good for you, dude.
And please go ahead and be as angry as you like as you continue your work for the defense in this case.
So you probably detected a little sarcasm there from the prosecutor. The defense, meanwhile, fighting back against the claim that their expert violated that non-dissemination order.
We didn't violate the non-dissemination order. And the information that now he's calling facts, he's flip-flopping between whether or not it's a false fact or a fact that's in the survey. The information that was put in the survey is based on the public record and information, the way that the state and state actors put information into the public record that has now been disseminated. And we have not violated that order. And I do resent being accused of that.
But Judge John Judge said there were questions featured in the survey that included false information that may have been featured in media reports or on social media, but those were not discussed in an actual public document or record, and that concerned him.
I mean, those two questions were not in the public record. And they weren't. I mean, they came out, but that was not the court, I mean, where it came from. It just came out of the media or somewhere. Who knows where it came from? But I don't think there's anything, not that I'm aware of, in the public record that said anything about that, about your client.
Dr. Edelman testified that he knew about the non-dissemination order.
The existence of the non-dissemination order changed how you did your work?
No, it did not.
Have you worked in cases where there's a non-dissemination order at other times?
Many times.
And he said that just 3 to 4% of the people surveyed in Latah County didn't know about the case. The number of people in Latah County who did know about the case.
That is bullshit. Do you guys believe that? What statistic was that? Listen to that again. Listen to what Anjanette Levy says here.
And he said that just 3 to 4% of the people surveyed in Latah County didn't know about the case.
Oh, didn't know about the case. Okay. I don't even believe that much, but okay, that little. Okay.
The number of people in Latah County who did know about the case and had feelings about it was much, much higher.
Because we asked these questions, what we found is
how
that
can you in Latah County and not have feelings about it? My God, look at what happened. It was atrocious. It was like beyond words. I mean, that's a stupid thing to say.
one, like I said, very high recognition rate. So 79% of respondents knew at least 5 of these items. So the idea that we're undermining his due process rights, everybody knows all this stuff. Very high rates. 82% of respondents who recognized 7 of these items or more reported that he's guilty, compared to if they only knew 2 or fewer, only 29% thought he was guilty. And the average was 6.2. So the average number of these details people already know, 6.2.
How can that survey even be legitimate, though? Because you're giving them the information. You're asking if they have seen, heard, or read about it, and they're currently hearing and thinking about it. This is just, I think this is a freaking terrible idea. What do you guys think about this? Just comment and chat here. Throw me a bone. What do you guys think about this juror, temperature taking survey?
And Dr. Edelman explained that the information he included in his questions came from media reports and the affidavit filed in support of the murder charges, information that was already out in the public.
What I did, just want to be clear, is the standard practice in the industry, done hundreds of times in high-profile cases throughout this country. There's nothing I did to contaminate the jury pool. Everything I included was widely disseminated by the media in this county hundreds of times, if not more. I mean, most of it came directly from an affidavit that the government released in a press conference and encouraged everyone to report.
Did I tell you what questions to ask?
You did not.
Would you take my advice if I told you what questions to ask?
I would not. And I'll tell you why, is as I mentioned.
I'm so sorry, Veronica. You said you can't hear me clearly. Can you hear me better now? And is it just when I'm speaking or is it the video? Sorry about that. I honestly don't even know what I was just doing with the mic. I'm just so into this. I'm not even sure what my mic was doing, but let me know.
My role is to be an objective expert to provide the court with information so the court can make a decision on if any remedial measures are necessary. I don't care what questions you want in the survey, and I don't care what questions the government wants in the survey. What I want to do is conduct a
Bullshit. This is angering me. I do not like the defense at all right now.
valid survey that's objective, reliable, and provides meaningful information that can be used by the court.
I'll get you back to this update on Bryan Kohberger's case in just a moment, but I want to take a moment to tell you about Sheath Underwear. It's a really great company. My husband absolutely loves Sheath because they make the most comfortable underwear he's ever worn.
No,
I mean, it feels like
we're
a
not
soft cloud.
listening to
Actually,
her underwear advertisement. Bad, Anjanette. Bad. All right, here we go. Okay.
a truly comfortable pair of underwear. I think you should check it out. Judge did not make a decision on whether the survey would start over or whether it could continue in other counties. Judge pushed back the hearing for the change of venue motion to the end of June, which probably is going to push everything in this case back. Alan Turkheimer is a jury consultant, and he has conducted these surveys in the past. So, Alan, what are your thoughts on the questions that Dr. Edelman asked to potential jurors?
I think he's doing what he wants to do to try to get the result that he's hoping to get. And that happens all the time. Maybe he pushed things a little too much and is testing the limits by having some questions in there that aren't necessarily true. But then again, from the defense perspective, it's not always about what is truthful. It's about what potential jurors believe. And if they believe something that's not truthful or that hasn't happened, they need to know about it. And I think that's the perspective he's taking with this survey and those questions that straddle the line of, did it really happen versus was it possibly reported that way?
He offered an explanation for why he had to put false information in there. And he said it was really to test bias and that this is something he's done in the past. What is your response to that?
I think he gets some credibility by having experience doing this in the past. Now, every case is different. So he could say that he's done this in the past and maybe didn't have an issue with it. But of course, he probably certainly was in a different county, was a different trial, different set of circumstances. So it's good that he has this experience and seems to know what he's doing, but that doesn't mean that he can take the kind of liberties that he may have taken if the judge says it's not okay.
Now, it's very clear, very, very clear that the prosecution wants this trial held in Latah County. They don't want this trial moved. So that's why they're having so much heartburn over there. So they're saying, well, really our issue is the fact that this violated the non-dissemination order. False information was put out there. The judge shared that.
We don't need to hear them talking. I have a different thing for you. I'm sorry. I was just like, I'm so hard thinking about this right now. I just this is coming off as just being not good. I don't know. What do you guys think? Does anyone want to come up and speak rather than type in chat? Whatever you want to do is fine, but I'm going to provide the link if anyone would like to actually speak. Speak, Lulu, speak. Hi, Utter. How are you doing? I scheduled this at the very last minute, Utter. I'm so glad you're here, though. Utter, Nancy was asking me today about who is the person. She said you don't know, right? You don't know who the female Southern accent who can't stand Nicole Kessinger or that creator we despise. Do you know who that is? I got to find out who that is. Honeybun says the questions asked won't even be part of the trial. Right. The only reason asked was for the defense because they have nothing. I think that is possible. That is in the realm of all possibilities and well stated. Yeah. I mean, I think so everybody knows, including the judge, including both lawyers and everybody, all of us. That's all the people that count, that the whole world is listening to these pre-trial rulings, hearings, proceedings, more so I feel than really like any other case I can think of, having been a forever, ever true crime junior detective. Michael J. Rourke, I'm coming for you, baby. You better watch your back. I shouldn't have said that. You better watch your back and brush off the dandruff because that's a bad look for a man wearing a suit. So So when they are explicitly stating all of the questions that are contained in that Latah County potential juror survey, they are in effect, just like they've been doing all along with the exculpatory evidence, Bethany Funk shenanigans, and so many other things. They are putting that out into the atmosphere. They are putting that out into the environment that the prospective jury pool gets their life sustenance from. I mean, I don't, am I dumbing it down, or is that, am I seeing, do you feel that you also see clearly what the defense is doing as I am explaining to you? I hope that makes sense. I told y'all I had a long day. So if that didn't make sense to you and you didn't hear the beginning, I had a long day and I apologize. Okay, cool. Okay, awesome. Thank you, Utter. Perfect. Thank you. I appreciate that. Oh, it's okay. That's okay. It doesn't. I mean, if you want to come up, that's okay. I'm sure we just would adore your clingy little boy. It's all good. I mean, my son just like screams at his gaming whatever he's doing during live streams all the time, to the point where people have been like, "Do we need to call 911? What's going on?" Like, I know people joke about that, but people have actually been serious about that too. So your cute little boy would be fine. And I love my child too, but you know what I'm saying? Mm-mm. See, Giovanni says first was mad, hard, second threat a little snowflakey. Okay. That's what I was going for, because I don't want them to falsely accuse me of actually making a real THREAT. You know what I mean? Yeah, we're gonna watch. We've gone over a little bit. We're gonna watch a little bit more of it. I tried to pick out some parts that are like the best parts. And and I love, and hey Sarah, and I love the way you worded that. So Sarah says, "Oh, I'm late, but did you watch the hearing today? The expert witness? Did you watch it, Sarah?" So I love the way that you worded that, because the prosecution does make a really good point during all of this. He says to the judge, I just got to say, I feel a little uncomfortable about this. The expert, the juror survey expert dude, was showing a PowerPoint presentation to sum up his information. And he says, this has not even been, agreed upon to go into evidence. Like, if this were this, I know, understand it's not a trial, but this is a pre-trial. It's leading up to the trial. It is part of the trial process. And I tend to agree with him on that without having any legal basis informing me, because I'm not really certain about using instructional displays like that in the pretrial portion of what's going on, but it did feel like that to me as well. Once again, to me, it felt like they were just sneaking shit in. Okay. Okay, so I'm just gonna bring this other one into the stream, because you guys are not answering my questions, but that's okay. I love you anyway. All right. Hold on, I gotta see which one it is I need to get. Okay. So. Oh, this is one you sent to me, McJ. Yeah, this is a really good one. Thank you for doing that. Okay. Okay, I'm going to stop at certain points, move forward, things we've already covered, or that aren't that interesting. But yeah, check this out.
Want to dedicate it to a hearing going on for Bryan Kohberger. My understanding is, if we can get a shot of that courtroom, the judge is now on the bench out there, and so we're going to take you out there.
I love this guy. He looks so formal all the time.
As was argued by Bryan Kohberger's attorneys. But the problem here is some of the questions involve information that was taken from the media about the case.
I'm going to allow this just beginning conversing between these two, because I think they make some really good points, and then we'll just go to the actual hearing audio video.
This was not provided by the defense, at least according to their arguments. It was information. Yeah, and there's a gag order in the case. The judge didn't want anybody to put any information out there that could potentially prejudice jurors. So the state says, you know what, we can't let them do this. I want to get your thoughts on just the overall issue.
Hey, I have an idea. Let's rather prejudice jurors, not with the actual facts mixed in with some bullshit, but with total 100% bullshit that people actually believe, though. That's a great idea. I still cannot stand the strictness of this non-dissemination order, but maybe that's just me.
In this hearing.
Well, when it comes to change of venue, obviously, what you're looking to have is a neutral a jury, impartial jury, a jury that hasn't made up their mind. When you have high-profile cases, you have to balance the First Amendment right to free press, a transparent and open court to the public, and that of the issue of whether the jury might be unfairly prejudiced by the coverage, depending on where the coverage leans. You don't want a jury to start a case with their minds already made up. With that being said, if the defense feels that the media coverage has been so overwhelming and it's been determined by either a poll or some type of other external information that the jury may be prejudiced and their client won't have a fair trial, then I think it's fair grounds for the defense to make a motion to change the venue to a place where there'd been less coverage and less of a chance that a jury in that new location would have already made up their mind before starting to hear the evidence.
All right, sounds good. Darnell, stand by, because my understanding is things have gotten underway in that.
And how awesome was Darnell's bow tie? It was awesome.
Courtroom. Let's take you out there live.
The state, can you hear me okay?
Yes.
Yeah, okay. I think we have Mr. Nye and Ms. Beatty on Zoom. Anybody else on Zoom? Ms. Taylor?
No, Mr. Logston is not going to be on Zoom today. He had the other hearing.
Ms. Beatty made it apparently. So, and I have also, you have Mr. Edelman, Dr. Edelman here today.
I do, Your Honor.
Okay. Great. So I think what we're doing today is just a continuation about the questions, particularly on the surveys and where we go from here. You did drop off a sealed exhibit, right? Anything to say about this, or just?
Yes, Your Honor. That sealed exhibit goes with one of our discovery requests, that the exhibit that outlines what we're requesting has to be under seal. And so I had to hand deliver that to the court. A copy was hand delivered to the state. It is not up for discussion today.
Okay, great. Thank you. One other thing to just tie up is the order unsealing the state's motion for order prohibiting contact with prospective jurors. There was a discussion between both of you about redacting a particular sentence, maybe last time, and so that we were going to take care of that.
I didn't. Ms. Taylor indicated that there was a sentence she thought we might want to consider redacting. I haven't heard back on that, and I know that she's been busy on other things since the 6th.
You want to just talk to each other for a second?
I understand the microphones in the courtroom are very sensitive. Perhaps we should do this after court today and go ahead and do the testimony of Dr. Edelman first. I'd be happy to talk to the state afterwards.
Thanks. All right, so is that where we're starting now?
Yes, Your Honor.
Actually, Judge, I think we need to discuss the preliminary matters first.
Okay, go ahead.
As Your Honor indicated just a moment ago, this is a continuation of where we were on the 6th. And the issues on the 6th and the issues that we have here today is first, whether there was a violation of the non-dissemination order. And if so, where do we go forward from that point? And I think it was clear from our discussions on the 6th that the fact-specific questions did violate the order. I realize that the defense would like to proceed with those questions. That's perhaps an issue for today. But I just wanted to define what we're looking at today, because about 10:45 this morning, we got what was up on the screen there, a PowerPoint that apparently Mr. Edelman prepared. And as I understand, I don't think Ms. Taylor got it until sometime this morning herself. That's the information that I was given. And we have concerns because a large part of this PowerPoint deals with the issue of a change of venue itself, which is we are not prepared to address. It is not before the court at this time. It is premature. And I don't think that it should be part of this record as we proceed forward today. And so the state took a copy of preparing a
Claps, claps, claps all around. Snaps, claps, claps. And yes, well said. I agree. For those of you who are listening, do you agree with Bill Thompson Claus?
printout of the PowerPoint. It doesn't take long to look through it. Perhaps the court might want to take a look at that before we proceed, at least with eliciting things from the PowerPoint. And I realize it's last minute, but the last time that we presented something to the court in advance, Ms. Taylor complained profusely, and I realized it was only 10:45 when we got this today, and so we just figured we would raise it with you now.
Okay, thank you, Mr. Thompson. Ms. Taylor?
Your Honor, I would disagree with counsel that the court made a determination that we violated the non-dissemination order. In my mind, that issue is very right for the court today, as is where do we go from here with the survey? Dr. Edelman has made himself available in court to explain the survey, the process of the survey, why it works, how long it's been used, how widely it's used, and what it doesn't do, and what it does do to present the court with some options to make a decision where we go from here. Whether the court decides we violated the non-dissemination order or not is up for discussion, and we're prepared to further argue that, but we think you need to hear the testimony first. As far as this PowerPoint, I had access to Dr. Edelman yesterday afternoon, and we worked on it late. I didn't have a final copy to give to the state until this morning. So they have it. We are not arguing venue now. We're talking about survey and how that relates to our change of venue motion. We know we're arguing the venue change later, but we have work that we still need to do. And that's where we are today, and would ask to present our PowerPoint and present our testimony with Dr. Edelman as we've prepared to do.
Okay. Taylor, so
Actually, Your Honor, Ms. Taylor still has a copy of the PowerPoint that I made available to the court.
okay, so it seems like this happens to me in this case that there's an argument about whether I should go ahead on something or provide some information that I don't see yet. So I feel like sometimes I'm making decisions that I'm in the blind here. So
Well, maybe you shouldn't be doing that, Judge, since this is your courtroom and you are the judge, presider over the whatever's going on in your courtroom. I mean, judge, losing favorability points by creator of What's the Obsession daily at this point.
I'm gonna look this over. Any problem with that, Ms. Taylor?
Well, Judge, give me just 1 second. Your Honor, the purpose of the PowerPoint is to inform the court about the questions in the survey and the purpose of them. I can tell the court that showing up every time we want to have a hearing and have to fight to have the actual hearing is something I haven't experienced before either. There is nothing in that PowerPoint that the court can't hear today when making the decision about where do we go from here and did I violate the non-dissemination order. There's just nothing wrong with the process that we're doing here, and you're continually being asked to say there's something wrong with what we're doing. We're 10 after 4. I have a witness who's traveled here today.
Holy shit. I'm so sorry. I have to just say, I almost think they should not have televised perhaps all of the pretrial hearings, because what she just said is not true because of the national interest and publicity of what we are looking at right now. So there's nothing wrong with what's going to happen here. It's though they are in a little, like county seat courthouse, behind closed doors with, the local sheriffs or whoever at the door and nobody in but the few people that are there talking about the legal issues and, oh, yeah, the defendant, right? But that is not the case here. And my spidey behavioral therapist sense about what she is doing right now is that she is being very dishonest and deceptive. And what she truly knows is exactly what she's doing. And that, having this expert witness come forth and talking about this, oh, it's okay that we have this happen right here, right now. It's not just happening right here, right now, Ann Taylor. It's as soon as you do it and Judge Judd puts it on his YouTube channel. Hey, Judge, would you like to come be a guest on What's the Obsession Friday night date night tomorrow night? Then the whole world has access to it. It's much different than what she's stating and trying to sound like this demure little, little country folk lawyer. It's just like this act is not working for me right now. What do you guys think?
Okay, and we're ready to go.
All right, Your Honor, just to clarify, as we made clear the last time we report, we are not saying Ms. Taylor herself violated the non-dissemination rule. We're saying that the people who prepared the survey and disseminated the survey and called citizens of Latah County with those fact-specific loaded questions violated the non-dissemination order, and they are agents of the defense. So I don't want this to become personal between Ms. Taylor and myself. We are not alleging Ms. Taylor has done anything wrong. We are dealing with reality that this survey was conducted on, as we understand it, 400, I'll say, innocent citizens of Latah County who were force-fed information that they may or may not have had about this case before they were called by the survey takers. And they are loaded questions. Some of the questions are factually wrong. They simply aren't true. That's what we're here about.
And that's what we're prepared to address, Your Honor. That's why we have a witness here. And if there's violation of the non-dissemination order, it's me. I'm the one that's bound by it. And the court just needs to hear about this process instead of hearing the conclusion that the state wants the court to reach.
Well, wait a minute. Hold up,
Ann
Taylor. Hold up, Ann Taylor. I didn't hear you even say that before, but now I'm even more angry at your folksy ways, okay? Because you're doing, okay. I'm not going to talk to her like a weird. I'm going to talk to you guys. What I'm observing that she is doing right now is employing the exact same technique that she used when she put out that motion to compel the testimony of Bethany Frank at the pretrial hearing before the grand jury convened, and there was no pretrial hearing to be heard of or thought of or that ever existed in history books or the fairy tale books for that matter. She is getting another expert to do or say the dirty work or words that she does not want to do legally, because if she were to say the things that her expert that she just brought on for that one motion, if she were to say that in her own words in that motion filed in court, it is of my opinion and the opinion of other esteemed people who know more about the law than myself that I talk to, that she would not be using, fair. I can't think of the term right now. She would not be meeting her legal standard of honesty. Okay. That's just in my words. I can't think of the actual term right now. And she, I believe, is doing the same thing again right here with Dude Edelman or whatever his name is. Survey guy, the science guy. Sorry. She's, wanting to get information out there once again to the public that she would not be able to get out to the public herself. Certainly not now, because she would be going against the judge's orders, and that would be all kinds of bad for her. So she's just having someone else do it. And then she's gonna, he's gonna do his job. She's gonna discard him. And if Judge allows this to continue, I believe she will continue to do this right up until the trial and on through the trial. Does that make sense? I hope it does, because I feel pretty clear about that. And I think this is something really important that we need to be watching out for and not allowing Judge and Michael Rourke,
I'm past that. I'm not going to violate you. I mean, this was a communication problem with Dr. Edelman not getting the order. one of the things I think that maybe need to clear up, not for counsel, but maybe the public, is that one of the terms in that, and this is in the ethics, right, is what is the public record. Public record is not traditional media. It's not social media. It's not what anyone might say in public. Okay, that's the problem that we're kind of balancing here, because the public record is case that is available to the public in this case. I mean, I think we can all agree with that. No?
No.
You think the public record is whatever the media pumps out?
Your Honor, I think it's what's in the public, and what's in the public is derived from the affidavit that supported probable cause to arrest Bryan Kohberger. That's the first document that the court finds in the whole cases of interest on Idaho State Supreme Court's website. That document has a ton of information in it that relate to the questions in the survey for the case specific questions. So that document became public record, and that was spread far and wide all over the place and reported and interpreted repeatedly. That's the public record. That's where the questions came from. There's no violation of the non-dissemination order if that's what we're going to talk about today. But I think the court should hear from our witness and understand a little bit more about this survey process.
I'm very interested in that. I told you last time that I'm interested in what he has to say about this, but
all right, as I mentioned, the questions in doing surveys is not uncommon. The issue is the type of questions. Normally, you'll call someone and you'll say, "Hey, what do you know about this case?" Those are general questions. Here, they're asking specific questions. Did you know that DNA from Bryan Kohberger was found on a sheet?
This is exactly what my friend Alex said, and this was I'm sorry, I didn't specify the two. This was exactly his problem with it, and he said that it is truly unprecedented to run a pretrial jury feeler temperature taker survey like this and to actually put out detailed facts or non-facts. He's like that it's completely unethical, and he's thinking that it's possible that somebody outside of this court is going to find that as being unethical, and this could cause a lot of problems for this trial actually ever going down with a verdict that sticks. My God, the poor victims' families. What kind of games are we playing here, guys? Freaking do this right. It's important stuff.
Did you know he was arrested at his parents' house? Very specific questions, giving information to people who might not have already had it. That's where the problem comes in. They're going to continue to argue that on the other side. We'll take a break. Keep it here on Court TV.
Tonight on Closing Arguments, new insight into the defense's theory of the case in the Doomsday Prophet murder trial. We're breaking down today's opening statements as this trial gets underway. And a woman who pleaded guilty as a child to the infamous Slender Man stabbing.
How about this?
Is
I
back
can't
in
believe
court
she's a
seeking
grown-ass
release.
adult now.
We'll unpack key moments from today's hearing with reaction.
I'm going to
from
watch
our
that
think
later.
Closing
Tomorrow.
Arguments with Vinny Politan.
Someday in my dreams. I don't have time for that. Well, I know I'm going to make time for it because I'm really interested. All right. I'm going to just blow past bow tie. And what did you say? It looks like the other guy looks like his suit is couch fabric. So we'll call him bow tie and couchy. And we're going to go right to Judge. Not doing his job well today, I'm sorry to say.
With Ms. Taylor, the defense attorney. We're not even saying she did this or violated.
Let me go. Let's see, we hear everything he says. All right.
Prosecution here is saying we have no problem with Ms. Taylor, the defense attorney. We're not even saying she did this or violated this.
All right, hold on.
public record comes out of the case, right? That's public.
I'm saying in this case, that's exactly what happened, Judge. I don't want to argue the finer points of what's in the media, but I'm saying in this case, that's exactly what happened. That affidavit's there, and this court knows we have a ton of things that are filed under seal and more things that are not filed under seal. But that affidavit that began this case has been shared far and wide, and media stories have generated. When you understand how Dr. Edelman does his work to determine if a survey even needs to happen, you'll know where the information came from.
Okay, so I I'm understanding, okay, the initial probable cause affidavit is part of the public record. And you're saying, well, that got spread, okay, by the media, as you would expect. And that's something that could be concerned. So what I think maybe, I don't know, what Mr. Thompson is talking about though is information or questions that were not. And so what I'm nervous about this is I don't want to continue to spread things out that shouldn't be spread. And so I don't know what's in the slides, but if there's information in the slides that are not in the public record, that really have not been disseminated generally, then I mean, I don't really want to spread it. None of us want to spread it more than necessary.
Well, last week in court, that was right inside the courtroom. That all became part of the public record. The 9 questions were stated repeatedly in different formats by Mr. Thompson. That's part of the public record. We've been accused of violating the non-dissemination order. Dr. Edelman's reputation has been impugned by what was stated about him repeatedly. Those questions are fair game. But having this hearing and allowing our expert to talk about this process, that's not the problem. The problem with the media happened a long time ago, and it started with the sharing of the affidavit far and wide.
I understand that. I'm pulled in 2 different directions right now because I'm trying to protect your client at the same time. So if we keep talking about this, what is not true, okay, I mean, I guess we can just say, well, it's not true on some of these questions. Maybe that helps to reduce bias. But if we don't make that clear, then it could increase bias.
Judge, listen. As we all know, and I stated earlier, I dropped out of law school halfway through, okay, bro? But I did have a full scholarship. Now here, I have an idea for you. Why don't we not worry about all of that and just follow the protocol for juror temperature taking surveys like this one, according to a whole shitload of really good attorneys that I've heard from today about this, including one that I know personally and know is the bomb, that questions of this level of detail are going to be destructive to the integrity of the trial when the actual facts are laid out, when the actual witnesses testify under oath, and all of that good stuff that we like to keep in place to preserve this idea of justice that we like in our society. So why don't we just throw out all the details like good little kids, tell them to redo your survey, submit it first, I'll give you an A or I'll give you an F, and we'll go from there. And I just can't believe he's even entertaining these questions. Makes me wish I finished law school and was sitting in his judgy place. I'm just kidding. But seriously, this is not, maybe I'm wrong. This is not impressive in my opinion.
I think, I don't know, tell me, maybe I'll hear this from the expert.
I'm going to say it like this. Mr. Kohberger is my client, and his rights are of the utmost importance to me. Him being treated fair, his presumption of innocence, him having an impartial jury, those are important things to me, as is his right to counsel. I am not standing up here saying, let me tell you about— Wait,
Chris, have you been holding out on me? Chris says, I literally write jury polling questions. This is painful. Chris, tell me what you know. Are these questions way too detailed? I'm just going to sit here. I'm going to put on my tick timer until you answer because I did not know that. I like this. Here, so you know me well, sis. Giovanni's Pikachu says, Kelly's about to be held in contempt. And sis says, Kelly lives in contempt. You know me too well. Chris. Yes. Okay. Oh, hey, Honey Bun. Thank you so much for the super chat. She says, this is a clusterfuck. It is such a super clusterfuck. So, okay, Chris. Okay. So the question I just asked Chris was Chris, who has a doctorate degree in human behavior. I'm not sure if it's therapy or I do not have that. So she is even shining with more knowledge, which I'm not like being, I'm being serious. Like I really like her and I love what she has to say and respect her. So she writes jury polling questions. And the question I just asked Chris, does it still say that? Yeah. Was, are these questions far too detailed? And she chimed in with a resounding YES capital letters followed by several exclamation points. Yeah, I mean, why? The feeling to me that I'm getting is that Ann Taylor is like, yes, motherfucker, I can play any game I want. Judge is like, go ahead, I'll roll the dice for you, even no big deal. Do you want to put a wager on that? I also like illegal gambling when it comes to quadruple homicide trials. But what is he doing? How does he know that these questions are too frustration, guys, frustration. Oh yeah, Chris, I would love for you to come up. I was just going to do that, but then I got overly frustrated. Yeah, I'm going to put the link in chat. If you want to come up, Chris, if you're doing other things, that's totally okay, but I would love for you to come up if you would like to come up. Link to panel. Here you go, sweetheart. Your call. We will love you either way. And panel is always better if you're here, so that's always an invitation, open invitation.
About this survey.
Wait, what's that? Just say it out loud.
Let me finish.
Just 1 second. I'm going to mute it. Hold it. Just 1 second, guys. All right. Sorry. My son has a really bad headache. I do too, actually. I don't know what it is.
Finish this survey to hurt him. I'm saying there is pervasive media coverage in this case. It's prejudicial media coverage. We've conducted a survey in Latah County. That survey is going to show bias and that you shouldn't have a trial in this county. What I'm trying to do is say, do you want me to give you information about another place where maybe the bias isn't so great, where maybe Mr. Kohberger can have a fair trial? I'm his advocate. I want to help him. I believe in his innocence. I'm not going to stand in this courtroom and do anything wrong to him at all. I need you to hear the information so you can make a decision, to have the surveys, to have the information when we come back here for change of venue and make a decision on all of the information. Right now, if we come in and do our change of venue, we're going to say you can't have this jury in Latah County, but I can't tell you a better place.
Wait a minute. Did I just miss when she was just gushing over her client? Did I just miss that? I may have, because I was saying envision exactly, get on with the administration of justice in your courtroom and get over all this nonsense. It's just really not looking good. I'm almost like, yeah, change venues as long as that means a change in judge. I did not like him at all at first. I had the exact same vibe that I am currently having right now and that yucky feeling in my tummy. But then I started to be like, okay. And y'all convinced me. A couple of you convinced me, but nope. I'm going back to my gut feeling, with logical reasoning as well, not just gut and logic. What the hell am I doing right now? I'm gonna press. Oh no. We need to go back so we can make sure we hear her gushing over her client. We will see some canoodling.
Formats by Mr. Thompson.
None of us want to spread it more than necessary.
Well, last week in court, that was right inside the courtroom. That all became part of the public record. The 9 questions were stated repeatedly in different formats by Mr. Thompson. That's part of the public record. We've been accused of violating the non-dissemination order. Dr. Edelman's reputation has been impugned by what was stated about him repeatedly. Those questions are fair game.
No. His reputation was not impugned by what was stated about him previously. The only thing that was stated about him previously, for your information, Miss Ann Taylor Esquire, is that Judge said, I'm very surprised that between the two of you, you didn't figure out that these questions were improper. And they are, according to everybody who knows what the actual fuck they're talking about, which is not me, but I'm relying on all you, and I believe you, experts, accomplished people. Good for you, and thank you for letting us know that this is not right, which I think most of us had the feeling of that anyway.
But having this hearing and allowing our expert to talk about this process, that's not the problem. The problem with the media happened a long time ago, and it started with the sharing of the affidavit far and wide.
I understand that. I'm pulled in 2 different directions right now because I'm trying to protect your client at the same time. So if we keep talking about this, what is not true. Okay, I mean, I guess we can just say, well, it's not true on some of these questions. Maybe that helps to reduce bias. But if we don't make that clear, then it could increase bias. I think. I don't know. Tell me. Maybe I'll hear this from the expert.
I'm going to say it like this. Mr. Kohberger is my client, and his rights are of the utmost importance to me. Him being treated fair, his presumption of innocence, him having an impartial jury, those are important things to me, as is his right to counsel. I am not standing up here saying, let me tell you about this survey. Let me finish this survey to hurt him. I'm saying there is pervasive media coverage in this case. It's prejudicial media coverage. We've conducted a survey in Latah County. That survey is going to show bias and that you shouldn't have a trial.
Let me tell you one more thing, sister, okay? Let me just tell you one more thing, Ann Taylor Esquire. Anything that is not presented in trial and is proven to be fact through evidence and data and expert testimony is prejudicial. That's the definition.
In this county. What I'm trying to do is say, do you want me to give you information about another place where maybe the bias isn't so great, where maybe Mr. Kohberger can have a fair trial? I'm his advocate. I want to help him. I believe in his innocence. I'm not going to stand in this courtroom and do anything wrong to him at all. I need you to hear the information so you can make a decision, to have the surveys, to have the information when we come back here for change of venue and make a decision on all of the information. Right now, if we come in and do our change of venue, we're going to say you can't have this jury in Latah County, but I can't tell you a better place that will protect him better. And that's what I want to do.
Any response, Mr. Thompson?
Whoa.
We aren't here to argue about venue today. We aren't here to.
Moderators, proceed to moderate. There are flashing police lights right literally outside my window, and I need to go be nosy and see what is going on. Keep going. Yeah, I know. What is up? Is there just one or how many? Oh, sorry. I'm going to miss out for a second. It's okay, McJay. I'll figure that out with you later, sweetie. I don't want her to stress about it. I'm not sure what's the problem with the new format. I hate it when they switch formats.
Argue about what this particular survey with the loaded questions, fact-loaded questions, may have produced in Latah County residents. As we mentioned last week, the structure of those questions assumes that every person that is called has heard all of the media in this case. And we know that that just simply isn't true. So for those citizens in this county who have not heard all of the rumors, who have not been following the media, who haven't inspected the court record, who are essentially ignorant of facts in this case, well, that's just been jaundiced by the questions that were asked. They have now been force-fed facts, some of which are not true, some of which would not be offered in court, and in fact, probably wouldn't legally be admissible in court, to somebody who may never have heard them before. That's the state's concern about the way this thing is put together.
All right, really strong arguments on both sides, actually. Tough position for the judge, and it sounds like we will get to hear from Dr. Edelman, the guy who crafted this survey, in a little while. So keep it here on Court TV, your front row seat to justice.
I'm Matt Johnson in Boise, Idaho for the Doomsday Prophet murder trial. You're watching Court TV, your front row seat to justice.
Please excuse that nosy neighbor moment. There's actually been there was something really crazy that happened yesterday that resulted in a full-blown police chase. Like, it was insane. But I'm not here to talk about that right now. Maybe another time. It's actually, I would if I was like Friday night, but I have to go to work tomorrow. Okay. So yeah, great point, Chris. Like Chris. She said, which one? Where was that comment? Oh yeah. Knowledge of a case and bias aren't the same thing. Such a great point. So it's almost like, given the questions that we know that were put on to that potential juror temperature taker survey by expert Dr. Edelman, who's a doctor and making these kinds of surveys, they're not going to decipher between the two. Great. I mean, that's a super awesome point, which really proves, in my opinion, that the whole exercise is frivolous, futile, and what it's really about, once again, is her getting another expert to disseminate information that she wants disseminated for her side of the case to stack the deck that is prohibited by the non-dissemination order. Gavel drop. I can't believe he's letting this happen.
Their ability to sit as jurors. She's simply irresponsible. It doesn't make sense.
Listen, this is one of the things that I was thinking about, is maybe we can inoculate by saying you can't rely on any of this information. It's not established by evidence. It's not been provided in court. But to just send a message out to be clear that these questions have nothing to do with guilt or innocence or even truth.
But that's not what was done, Judge.
I know. We have to fix this in some way.
Yes, sir.
That's what you said last time. And so I just want to help the public understand that this is not the trial.
Your Honor?
Yes.
Wait. Judge. We gotta talk. Come over here. Step down. Can you just step down from the bench for a minute? You're looking kind of tall up there. I'm a little intimidated. We gotta talk. All right. It is not your job at this point to convince the public of anything, okay? You made the rulings that you made that are allowing this trial and also the pre-trial, every fucking things that are going on to be put on your YouTube channel, okay? And you better not be monetized. For literally all the world to see. You already made the decision of what you're telling the public. You're telling the public everything, and that's fine. A lot of people think that's how it should be. In the beginning, that's how I thought it should be. But now that I see what's going on, I guess maybe I don't think that anymore because I'm embarrassed, I guess. Yeah, this is a really great example of our justice system working well. Amazing. Awesome. Cool. More trolls. Great. But it's not your job now to explain to the public that this is not the actual trial. This is the pre-trial. And when we have, things that look like evidence, they're not really submitted evidence. And when we have experts, they're just talking. They're not really under, sworn testimony. Yo, that is going to most people are not even going to comprehend that. Most people are like putting in their earbuds and listening to Kanye or going and making a coffee or taking a pee or whatever when you start talking about that stuff because they don't really care because they just want the juicy juice. So I just feel like he's missing the point on everything. Kanye for judge.
We know this isn't the trial. We brought Dr. Edelman to talk about the process, which will answer the state's concerns about this process. He hasn't even had a chance to tell you how this is constructed. He's the one that's the doctor of this kind of work. He's the one that's the professional. He's the one that knows how to do this. He's the one that spent his career understanding surveys and how to construct these. You need to hear from him. Going back and forth between what Bill thinks and what I think doesn't matter. What matters is you hearing from the expert to make a decision. He's here, he's ready to testify. We're 20 minutes into this hearing and he hasn't been allowed to take the stand yet. He came to inform the court about this process.
Well, there's no question I'm going to let him testify. I just wondered about what's in this. I haven't looked at this, but it's you're comfortable having this come out into the public?
Yes, after last week's hearing, absolutely.
Okay, and you looked at it, Mr. Thompson?
We have concerns, Judge.
Alarming?
Well, part of what's in there is a part of the survey study being published now, if this comes to the public, without any comparison to anything else. And it's the product of these loaded questions. It takes us back to the fundamental issue of how this survey was conducted and the assumption that the people who were being called already knew all this stuff. And so it didn't hurt to specifically ask them, have you heard about such and such, the specific item?
And to make that assumption is fucking moronic. I'm sorry. It is completely moronic. And I do not believe in a million bazillion years that an attorney, Esquire, and a doctor of whatever he is, the survey maker guy, temperature taker man, are so stupid to think that this survey was not going to do as much or far more harm to the potential jury pool and the jurors' minds, because they're all under mind control at this point. And Taylor, sound familiar? Then it's doing good to just simply survey them to see if there needs to be a change in venue for the sake of justice. I don't buy the, hey man, all this is about is we need to find out if we need to have a change in venue for the sake of justice so he gets fair trial. Bullshit. I do not buy that for a hot second anymore. I never really did buy it, but there are moments where I was like, okay, maybe I could buy that garbage. Maybe I could buy that plastic crap. Maybe I will buy it and I will convince myself that it's just fine and it's okay and whatever. But no, now I am saying no. I'm saying no to your plastic garbage, toys, legal arguments, lies, junk. This is crazy. I can't believe that he's allowing her to get away with this, because there are so many problems down the road if this continues. There probably already are. I need to take a breath. I'm going to press play.
Well, if they hadn't heard about it before, they sure as heck have heard about it now. That's the core concern that led us to this in the first place. We don't dispute the defense doing a survey. I said that last week. Please do a survey, but don't go around screwing with the knowledge that prospective jurors have or may not have.
Thank you.
That's our concern. And, Your Honor, when we parted ways last week, the court said, Ms. Taylor, talk with Mr. Edelman and see what the options are. Well, my understanding from the email I received day before yesterday is the survey cannot be changed. That was from Ms. Taylor reporting what Dr. Edelman said. I interpret that as they don't want to change it. Anything can be done.
The survey cannot be changed. Are you fucking kidding me? See, Ann Taylor's head is getting a little too big for her shoulders here. She thinks everyone else around her is stupid, and that all of us out here, hi, professional, super annoying true crime sleuth junior detectives here, we see right through you. Like, this is just, I don't know if she's like, kind of being smart because she's getting away with it, so she's going to keep doing it. And that's kind of smart, I guess, if you're moving towards your objective, or if she's just really that unskilled and or desperate, which are really two separate things. But all those options to me are very troubling.
But that's where we're left. I would have been happy to engage in discussion with defense about maybe some middle ground, but the line has been drawn black and white. I am concerned about the specific things that relate to venue, partial survey results that are in this PowerPoint. I don't think it's I believe it is premature for them to come out now.
Yeah.
The rest of it is fine. Let's bring it out so that you have whatever information you want. You can give it the weight that you decide. I just didn't want to let this willy-nilly come into the public record in a half-baked fashion.
I have lots of concerns. We're not.
We have concerns too, Judge. And just in case you weren't here in the beginning of the live stream, I had one hell of a day today. So that's why I'm in gummy need mode. And I would love a gummy.
This because I have to make a decision about several things.
Yes, sir.
And so in order for me to have the most informed decision, I need the information. So they're just going to go ahead. All right.
Thank you.
And you can show your slides, and if something is concerning, we can talk about it along with it. All right. So, are you ready to call your witness? I think you are.
I am. I'm ready to call Dr. Bryan Kohberger.
All right, we're going to take a break here. When we come back, Dr. Edelman will be taking the stand to explain his surveys, why they're crafted this way, to figure out if there's bias.
I can't fucking wait to hear from Dr. Edelman. It's going to be great. All right, let me get there. I'm so excited. Dr. fucking Edelman. Please, people get doctors for the dumbest reasons. All right.
Typically, okay. And to do with surveys, just to be clear.
Yes. From some it's surveys, other times it's post conviction.
At the very beginning.
Regarding some surveys being used by the defense, they have called now Dr. Bryan Edelman to the stand. He is the scientist or the trial consultant that really constructed these surveys in question, and he's a change of venue expert. So let's get into the courtroom now to listen to his testimony.
He's a change of venue expert. He's Reed. Hey, psst, psst, yo, defense attorney. It looks like you are fucked. You come over here, you pay me a here's the fee, sign online. Here's my bill of goods. This is all I'm going to need from you to collect. Yeah, I do take credit card. Yes, I do. I'm going to come up with some strategies so you can just dance around that little judge clown of yours sitting up there on the whatever he's sitting up on bench. And yeah, let's do this. Like, this is really what this is seeming like to me. And I do not like it because I like real justice, not fake justice or pretend justice. And also, seriously, like, this crime was horrible. And the victims' families, come on, people. Like, they need to get it together here.
I've been doing this for about 15 years, I'd say, as an expert witness on this area.
On change of venue, typically? Okay. And to do with surveys, just to be clear?
Yes. From some it's surveys, other times it's post conviction. Once again, I've done federal cases, state cases, multiple states, including Idaho. But the way I learned was from Dr. Ed Bronson, who was kind of the pioneer in the field. He worked on cases like the Oklahoma City bombing case and a host of other prominent ones, the Boston Marathon, a bunch of them. So he was kind of my mentor in this area. And there's a 3-stage process. So the first phase is collecting the media coverage. Is really the question is.
Wait a minute. Hold it. Chris, wait a minute. I bet you are, like me, an actual expert on creating and conducting certain types of surveys, right? Within a range, within a parameter, within a certain area of topic, expertise, age range, demographics, and all that stuff, right? I didn't realize that till even now. Now, a juror temperature taker survey? Nope, never done that before. But, okay, so I really want to listen to these steps here. Let's see if his steps to creating a survey. Now, he didn't say like a survey that follows the scientific method or a survey that is valid and replicable or reliable or any of those words that we like to hear when we are collecting data for the purposes of utilizing that data to determine information that cannot be seen because information, after all, is ephemeral and invisible. It's just a concept. But data can help us actually put our little dirty paws on it. So I know how to do this. And he didn't mention any of those good things. I'm going to go back 30 seconds. Get your dirty paws off your fake survey making whatever. I do not like these people.
Cases, state cases, multiple states.
Bullshit, liar, liar.
To his testimony.
I've been doing this for about 15 years, I'd say, as a expert witness on this area.
On change of venue
On change of
specifically? Okay. And to do with surveys, just to be clear?
Yes. From some of its surveys, other times it's post-conviction, once again. I've done it federal cases, state cases, multiple states, including Idaho. But the way I learned was from Dr. Ed Bronson, who was kind of the pioneer in the field. He worked on cases like the Oklahoma City bombing case.
A pioneer in the field, meaning he is the creator of the bullshitter.
Host of other prominent ones, Boston Marathon, a bunch of them. So he was kind of my mentor in this area. And there's a 3-stage process. So the first phase is collecting the media coverage. Because really the question is initially, is there extensive coverage and is there prejudicial coverage? So I collect the coverage and assess the nature of that
Homie, wait a minute,
include-
homie. I've got to have this same talk with you I had with your buddy Ann, and I just had with Judge. So come over here. We're just going to get like logical, rational. We might, have to pull a dictionary for you. Anything that is not, when it comes to justice, presented in a trial that is data supported, evidence based, testimony supported, all of those good things that we like to happen at a trial, so things are on the up and up. Anything else is by definition prejudicial. Oh my God, this is so amateur, and I am so upset that this is happening in this trial. This is such a huge trial. This is such a horrible, horrible crime. These victims deserve so much more. The victims' family members deserve so much more, and there's probably like nothing I can do about it other than like sit here and talk about with you guys and like get a headache from it. But I feel like I want to go fly to Idaho tomorrow and be like, what the fuck is going on, Lata? Move on out, because Watsy Obsession junior detective team is coming in. We are taking over. Come on, guys, we're moving in. There's desk for you. There's desk for you. You can have your own office if you want. Chris, you can have a whole department if you want. You're doing really good, by the way. Thank you. I mean, this is just insane.
Inflammatory language. Does it include inadmissible or misinformation? Now, just because it's not true does not mean people don't see it, and it does not mean that they don't develop opinions based on that information. So it's very important. In fact, some of that stuff is the most prejudicial stuff that there can possibly be.
It's all prejudicial.
For example, if there is a prior conviction and then the conviction's thrown out, well, that's pretty prejudicial for the new trial.
It's all prejudicial.
Not admissible, but very prejudicial.
Oh my God.
So I'm looking for information like that. I'm looking for references to prior record. Maybe there are victim impact statements where victims' families may be suggesting what the outcome should be. That could be prejudicial. How did the community respond? Are there candlelight vigils? Are there, GoFundMe efforts going on? The status of the victims, they're focusing on that. So there's a gambit of things that we look at. Sometimes there's political elements that are important in high-profile cases because it might be that a politician's involved. So it just depends on the case. So the first thing is assessing the nature of the publicity. Now, if there's not a lot of extensive pretrial publicity and it's not prejudicial, it stops there. And that's happened where there's coverage, but it's very superficial. It's very neutral. There's not a lot of detail. There's nothing particularly impactful. Maybe it's...
You know what? No. Maybe there is that coverage, but you know what? It's on networks or channels or whatever platform. People that aren't going to go anywhere, because if you're talking about things that are non-prejudicial and neutral and, oh, yay, this is the news. This is the true crime news. This is the quadruple homicide news for today. And it's all of those things nobody's going to watch. So like, seriously, let's get real. They are presenting Judge a picture of their reality as they would like Judge and the rest of the world to see it, that exists in like maybe Oz. I don't know, but it's not reality. And I just want to scream, but my head hurts too bad.
It's focused primarily on just the victim or something like that. However, there are other cases where there is extensive pretrial publicity, and then I would recommend phase 2, which is a community attitude survey. because just because there's prejudicial coverage does not mean it had an impact on the jury pool. And that is the question that matters most. What impact has the prejudicial media coverage had on the jury pool? I don't really care if it's correct information, it came from social media, it came from the news. It had an impact on the jury pool. That's what matters, because they develop opinions.
No, correct information is supposed to be delivered through the trial, through the presentation of your case, whether you're the defense or the prosecution, through evidence, through testimony, through sworn testimony, through data, through repetition and validity and pie charts and scientific method. And this is all going down the wrong track, and it is extremely upsetting.
And attitudes, and it doesn't make a difference.
I don't care about your fucking attitudes. I can't stand this guy. I'm so sorry. I know I'm really like on fire about this today, but this is, I listened to this in double time earlier, a few of these things, and I didn't like really catch the full spirit of it. And this is just, I just was going to say, I don't know what to say, but obviously I have things to say.
If that's true or false, they still develop an opinion and an attitude about the defendant, about the evidence and perceptions of guilt. All of that is what I'm looking at. So I want to see if the media coverage has had an impact. And that's how
Can you guys be talking about all things gummy when such important tragedies are happening right in front of our face? Tragedies of justice. Or maybe our ears, because this is just an audio, but okay, never mind.
community attitude survey. And then depending on the results of the survey, there's not enough evidence there to suggest that anything is required. It could be remedial measures such as individual sequestered blood gear. Maybe that's appropriate in some cases, all the way to the extreme case where it might be a change of venue.
I want to understand a little bit about the source of media you review to do your work. Can you tell me what you take a look at?
I always take a conservative. Your Honor, I'm sorry, I need to object.
Thank you, Bill.
This PowerPoint is being played for everybody with no foundation. It's not an exhibit.
I'm officially banning gummy talk. You guys are not paying enough attention to the horrible things that are going on. Stop talking about happy little gummy bears and start paying attention to the horrible things.
I think that's improper. I mean, I'm trying to listen to Dr. Edelman's testimony, and I keep seeing slides changing in front of me over here, and I don't think that's appropriate.
Well, you've seen the slides.
I have.
You looked at it.
Everybody else here hasn't.
Oh my God.
What I'm seeing here, though, is just an explanation of how he goes about in surveys.
Understand that. That's what his testimony is, but we're getting this visual aid that there's no foundation for, Judge.
And what Bill Thompson wants to say, and by the way, Judge, if you didn't catch that, we're going to have coffee later. I'm going to have to tell you about why what he just said is complete bullshit, and you better sharpen your game.
Well,
It just seems.
Well, hold on. I'm viewing him as an expert. Okay?
Yes, sir.
He's explaining what he does. So I'm going to.
No problem with that. The PowerPoint's a problem. I don't have any problem with his testimony.
I do, Bill.
All right.
I'm sorry. Frankly, I've never seen something like this occur.
Dude, and once again, the judge doesn't get. He's just like, all right, so your problem's not with his testimony. So what is it with? Because I'm really like a one-dimensional thinker. And by the way, I didn't really go to law school. I'm a stoner, baby. Give me some gummies. Oh no, he's going to start hanging out with us. That would be so bad. I don't like him. I don't want him as part of our channel community. No, judge. No, judge.
Objection. I mean, this is not necessarily factual. It's just an example of how he got to where he got.
That's his testimony, but the PowerPoint is different, Judge. I don't know why we're seeing the PowerPoint when we have his testimony.
You want to respond to that?
I do, Judge. This is a courtroom demonstrative aid that helps to track the testimony of Dr. Edelman. I can hand in my computer and let him advance the screens if that makes a big difference in it. But this just helps explain his testimony.
Judge, we don't have a jury here. Let's just proceed.
Okay. Thank you. Go ahead.
Dr. Edelman, we were talking about where you get your information.
We were talking about the what?
Where you get your information. What media do you look at? I think that's where.
Yes. So I take a conservative approach to how I do it. I look at newspapers in the local coverage right now. So I'm interested in papers that have primary circulation in the venue. Case like this has been reported in many other newspapers, but I wouldn't, for example, look at a newspaper published in Dallas because I don't know if somebody in Latah County would be looking at a paper in Dallas.
Dude,
so I look
oh my
at the
god!
local.
Oh my god! Is this like survey creating research kindergarten level? So I'm in Idaho, but I'm not going to look in a survey created in Switzerland, for example, because I don't know if the people in Idaho are going to be, the news. I don't think if they're going to be reading the local newspaper in Switzerland. This is a joke. This is if it wasn't my headache mood, I would be really pissed off. This is really not good. This is embarrassing. We should all be humiliated.
Coverage. I try to look at like local television coverage to see what the community is likely exposed to.
While we're here, I want to ask you some questions about the non-dissemination order.
Okay.
That's been a hot topic, and you've heard some of it again today. Are you aware that there's a non-dissemination order in this case?
Yes.
How did you become aware of it?
Well, the first time I became aware of it was when I was reading the newspaper coverage, because that was one of the topics of media coverage, was discussing the non-dissemination order and media's efforts to have it changed. So I was able to read it and follow it in that media coverage. So that's the first time I saw it.
And in January, did you receive an email from my office?
I don't believe Judge, or this guy could actually get through the New York Times. Send him something good. Send him something that has text to speech, just in case they can't sound out the big words.
With the non-dissemination order.
I believe I did.
And you looked at a hard copy again recently.
Yes.
All right. Does that non-dissemination order change how you did your work?
I'm sorry, can you even know?
Does the existence of the non-dissemination order change how you did your work?
No, it did not.
Have you worked in cases where there's a non-dissemination order at other times?
Many times.
Was the sole source of the information that you use contained in the media?
Was it came from the media? Sorry. Yes. Everything I used was widely disseminated through the media. Widely disseminated.
Did you find out where the media got the information?
Yes.
Angel D, I'm sorry, I didn't realize all that. Maybe we'll have to talk it out later if this is bothering you. I was just reading those comments. Aw, I appreciate you all the time.
All right.
Thank you.
And you can show your slides and
we skipped something because they can show the slides.
A line has been drawn black and white. I am concerned about the specific things that relate to venue, partial survey results that are in this PowerPoint. I believe it is premature for them to come out now. The rest of it is fine. Let's bring it out so that you have whatever information you want. You can give it the weight that you decide. I just didn't want to let this willy-nilly come into the public record.
Well, now it's there, and it's going to be embedded in our
I
brains like a parasitic worm for the rest of our natural lives.
lots of concerns. We're not left with this because I have to make a decision about several things.
Yes, sir.
And so in order for me to have the most informed decision, I need the information. So we're just going to go ahead. All right.
Thank you.
And you can show your slides, and if something is concerning, we can talk about it along with it. All right. So, are you ready to call your witness? I think you are.
I am. I'm ready to call Dr. Bryan Kohberger.
All right, we're going to take a break here. When we come back, Dr. Edelman will be taking the stand to explain his survey.
Willy-nilly, willy-nilly. I noticed that too. He keeps saying willy-nilly. Oh my God. Who are these people? Sorry, this is just like so atrocious. The couch fabric suit is starting to look really good. Oh my God. Yuck. In comparison. Oh, so mad.
Instructed these surveys in question, and he's a change of venue expert. So let's get into
the way I
He's nothing. I've
media
already heard this crap.
reference,
Crap,
and
crap,
that is the
crap,
question.
crap,
Video
crap, crap,
measures such as that's appropriate.
Well, you've seen the slides.
I have.
You looked at
Dude.
it.
And his own fucking slides. The source of information tested in the survey media coverage. That is so vague and oh God.
Everybody else here hasn't.
What I'm seeing here, though, is just an explanation of how he goes about in surveys.
Understand that. That's what his testimony is. But we're getting this visual aid that there's no foundation for, Judge.
Oh my God, that's so funny,
Well,
Giovanni.
It just seems highly unusual.
Well, hold on. I'm viewing him as an expert. Okay?
Yes, sir.
He's explaining what he does. So I'm going to.
No problem with that. The PowerPoint's a problem. I don't have any problem with his testimony.
Bill's like, no problem with that. I have no problem with him sounding like a first grader describing what his art project is. And you're like, oh my God, I thought it was a butterflies in a field of corn. And you're telling me that it's local newspapers in Tallahassee or something. Yeah. Breathe. Did Ann Taylor say yet that she 100% absolutely positively believes in the most earnest but kind of sing-songy and almost romantic voice that she believes that Bryan Kohberger is innocent? Did you guys hear her say that, or did I miss it? With all my screaming and belligerentness and whatnot in contempt of court. It's so gross. I mean, if she thinks that's fine, it was the way she's, I don't know. I just am getting bad. I'm getting all willy-nilly feelings about this, guys. I don't like it.
All right.
I'm sorry. I frankly, I've never seen something like this occur.
That objection. I mean, this is not necessarily factual. It's just an example of how he got to where he got.
That's his testimony, but the PowerPoint is different, Judge. I don't know why we're seeing the PowerPoint when we have his testimony.
You want to respond to that?
I do, Judge. This is a courtroom demonstrative aid that helps to track the testimony of Dr. Edelman. I can hand him my computer and let him advance the screens if that makes a big difference in it. This just helps explain his testimony.
Judge, we don't have a jury here. Let's just proceed.
Okay. Thank you. Go ahead.
Dr. Edelman, we were talking about where you get your information.
We were talking about the what?
Where you get your information. What media do you look at? I think that's where we were.
Yes. So I take a conservative approach to how I do it. I look at.
I like to look at
newspapers in
TMZ, the New York Post sometimes when my wife tells me that I have to so I can look legitimate. And sometimes comic books work for me pretty good because I have a hard time sounding out those big words.
Did you receive an email from my office with the non-dissemination order?
I believe I did.
Receive an email from my office.
How'd you find out about the non-dissemination order? You know, she's like, oh, well, I did some research on the case and blah, 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 blah. You know, saying the lines his wife fed him because in my mind, the story I'm creating about him is she's clearly much smarter than him because he's like, you know what I mean, willy-nilly. And then Ann Taylor's like, oh, and didn't you get a copy of it from my office? Like, congratulations, defense attorney. You disseminated your non-dissemination order. That's amazing. She gets a little twisted about it.
Non-dissemination order.
I believe I did.
And you looked at a hard copy Again, recently.
Yes.
All right. Does that non-dissemination order change how you did your work?
I'm sorry, can you know,
Does the existence of the non-dissemination order change how you did your work?
no, you did not.
Have you worked in cases where there's a non-dissemination order at other times?
Many times.
Was the sole source of the information that you used contained in the media?
Was it came from the media? Sorry. Yes. Everything I used was widely disseminated through the media. Widely disseminated.
Did you find out where the media got the information?
Yes.
Good afternoon, folks. My name's Bill Thompson. I'm the Latah County prosecutor.
And I am disgusted.
And it's sad to be here, but happy to be here at the same time.
You turn it up. I can't hear.
Kohberger.
Well, I'm gonna do my best to turn this up.
Oh, just a minute. I have to go get something to drink, like water. I'll be right back. Keep watching Bill.
Yeah, you get a fancy.
If I put the microphone up, is that better?
So yeah, but Christy, you don't have to type out things that are recorded here.
And let me preface, there is a pending case now in court, and I in my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time, we expect that affidavit will be available to you so you can share the true facts with all of your readers and your watchers and your listeners and all the people who are interested in really.
All right, that's going to wrap up our coverage for tonight. Thanks to my guest, Darnell Crossland, for being with us. I'm Michael Ayala. It's been a pleasure being with you.
Oh my gosh, I'll be right there. I'm doing some things other than watching that. I'll be right there.
You've been drinking that day, right?
Yeah, I had a
And
like
showing us the
beers.
mark is Exhibit 12A. You recognize that?
Yes.
That's the group photo of you folks from the beginning of the river.
Yep.
In fact, you're holding a beer.
Correct.
Looks like everybody in your group has some sort of alcoholic beverage.
Looks like it.
You see numerous people in your group with these phone cases around their necks.
Yeah.
And as you're going down the river, you saw lots of people with phone cases around their necks, right?
Mm-hmm.
All day long.
Yeah.
In fact, River sells or rents out those phone cases, right?
I don't know that.
Did people in your group rent or buy phone cases from the tube rental?
I have no idea.
Right.
Poor guy. I don't even want to talk about this case. I can't. I don't have the mental stamina right now. I didn't even get my drink of water yet. I was just picking up bunny poop. This is my life, guys. I can't look at Nikolai right now. I feel bad for him. When he testified, I just I feel really bad for him. Okay. No, please don't. Okay, gotcha. For fuck's sake, YouTube really wants me to watch this Apple River Chaos. I know it really is. I was home on spring break last week and I literally couldn't get around it. I always have autoplay on, and every time I walked out of the room, it was like Apple River stabbings, drunk teenagers, and aw, poor Nikolai Mew. I feel bad for him. I did not know how I felt about it in the beginning. I have made my decision, and now I do wish I was on that jury. He was acting in self-defense. He was scared for his life. I mean, I really think he was, given all of his kids. Wait, I'm not going to talk about that. Moving on. Edit mode. Okay, fine. Yeah, I did say picking up bunny poop. All of my bunnies poop. 300 poops a day per bunny. and I have 26. Do the math. Ann Taylor. Michael Rourke, there's your challenge. Do the math. How many bunny poops did my bunnies poop in one day? 300 poops per bunny, 26 bunnies. Do you think he could do it? Do you think he could? Probably. I'm not. Maybe. Maybe if he had a calculator. Yeah, they're sitting all. Oh, I know. It's all weird. It's just weird. It's weird. Yeah. Sorry, I'm just reading through some of your comments. Can't even follow this. Oh, I know. It's bad. It's bad. Okay, wow. This is, oh, God. Oh, shit. It is late. I gotta go. I gotta go to work in the morning. Oh, man. I don't want to go to work in the morning. I need a vacation, guys. Do y'all need a vacation too? Let's go on vacation. There you go, Angel. We could pose it like that to work, and that would definitely twist his brain up. He'd never figure it out. Don't ask her that. She'll need to hire another expert. Only if it is going to try to save Brian's ass in some sleazy, not legitimate way. The defense did pretty much everything they could. I applaud their work. Are you talking about Apple River? Oh, that I'm not sure which one you're talking about, but yeah, you have vacation. Yes, that is what's needed, Angel. Vacation on life. Yeah, a way lesser sentence, Chick Tracy. I think that's appropriate because I mean he didn't need to stay. I know, it's tough. I mean, a kid died, and yeah, I mean that was bad, but whew. I really am glad. I could. That would be those jurors are probably having a very, very hard time. I thought that was a heartbreaking case, in my opinion. I'm really not glad that YouTube forced me to watch it. Per Angel's same idea there. The water did not and should have played a factor. That's a really good point. Yeah. Considering they were on water. I agree, Truth Exposed. And is quadruple bypass surgery survivor, and he just had that surgery less than 2 years ago. And when we saw those pictures of him in the hospital, and he's like, what's that? That heart pillow looks like there's actually a heart and lungs on it. Did you bring that? He's like, no, they gave it to me. I'm holding it over my surgery so it protects my heart. I was like, oh my God. And then he started talking about his dog, whose name is, oh no, he said my Angel, by the way. And the lawyer's like, who's this? And he got all choked up and he goes, it's okay, you can answer. And Nikolai was all choked up. He's like, it's my baby. It's my Angel. And you can tell him, oh my God, he's just like a nice human being. Oh, I hope that they don't put him away for a while. Oh God. Another headache. This is bad. What's the world coming to? Yeah. Bunny poop, parrots, bunny poops, parrots. I can't have parrots because if I had any more poop I'd clean up my house, I would literally go certifiably fucking insane. I'm so tired of having things to do all the time. But I love my bunnies, and I love my YouTube, and I love my job, and all of that. But I'm tired. I know. Couldn't they have just floated past? They absolutely could have. Yeah. Water does change the whole dynamic. That's a really good point. Yeah, I know. Oh, I know. So sad. I read a coop. Wow, that's cool. Poop is just a part of life. It's just really better when it's less than 300 times 26 a day. What am I thinking? I'm a crazy person. Oh. Yeah, I think so too. Yeah. Aw. Okay, guys. All right. I gotta go because I gotta go to work tomorrow. Even though I don't want to because I have a headache and I have to clean up bunny poop. Maybe I can call my boss and be like, I can't come in today. I have to clean up bunny poop. That wouldn't go over well. My work is actually really awesome and flexible, but they expect us to be responsible, clearly. So if I did not go to work because I was cleaning up 300 times 26 bunny poops in that day, I certainly wouldn't tell them that's why I did not show up for my responsibilities. Roomba. Oh, God. I don't know why I'm laughing. That's not funny, Angel. What is wrong with us human species? Oh, no. Gummies for animal rights. I'll just leave it there. Oh, no. On that note, everybody, the Roomba and the dog with diarrhea thanks to Angel T. Oh, anaphylaxis is diving right in. She's conjuring up a mental image. Bunnies do, yeah, they do use a litter box. So I have 2 right now that are free runners. They're so lucky. Little Skylar and Lily. You guys have met Lily. I think you met Skylar a while ago, though. Lily's made her appearance the last couple times. And they just like run around the house and they have a litter box and they go in the litter box. It's amazing. And then all the other bunnies, wherever they are, if they're in the bunny barn or the cages, they all have litter boxes. But still, it's not a perfect thing. You know what I'm saying? And it's still messy. It's still 300 times 26 every day. Oh, good Lord. What am I thinking? I need to go rethink my life. I got to go rethink my life. I got big things to think about. Oh, hi, Sirius Black. How are you doing? Oh, gosh. I'm like just getting off. I'm so happy to see you. And there will be a What's the Obsession Friday night date night live stream tomorrow night. Yeah, she's cute, little girl. Yes. So be there for that. And I'm not going to say anything more about that because I really got to go. I got to go to work tomorrow because I can't not go because of bunny poop. So everybody have a good night. Lock your windows and your doors unless you live in a hut, in which case you should come up with some other security arrangement. I don't know. Oh my God, life is obviously really hard. So please be nice to each other and especially be good to yourself because you deserve it. Yes, you do. You do. Unless you're Judge or the, I don't know. I guess he does too. I'm just mad right now. I got to go. I'll see you guys tomorrow night. Probably like around 9:30. Yeah. All right. Everyone take care. Bye.